Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann.
And hello everyone, I'm Shauna Sanford. Welcome to the show. When it comes to our financial records, how many of us out there would love to get rid of everything and just start all over? Well, if you're in a tough money spot right now and you're thinking about declaring bankruptcy, stay tuned. It may or may not be the answer for you. Is it really a way to wipe your financial slate clean? You might be surprised to hear the answer to that question. Joining us today to talk about bankruptcy is attorney Claude Lightfoot.
What is the difference between filing Chapter 7 and Chapter 13? Many people have financial problems, but when declaring bankruptcy, is filing bankruptcy a viable option? How could it affect your future? Claude Lightfoot will help us answer these questions and many more.
Well, it's going to be a very interesting conversation to have with attorney Lightfoot, but before he joins us on set, if you could talk a little bit about the difference between corporate bankruptcy and consumer bankruptcy. What are some of the big differences?
Yeah, and just to paint a broad picture, again, this is not my area of specialty. That's why we bring in somebody who does this for his main job focus. Corporate is if you have a business, mom and pop business, if it's incorporated, or maybe it's a bigger business, a partnership. There's different types of entities. If that entity needs to file bankruptcy, there are certain laws that apply to them. If you're an individual, and you could be married, or if you're an individual, but if you're an adult, you are allowed to file bankruptcy under certain circumstances. Simple answer, maybe a little oversimplified. Chapter 7 is designed to wipe out most all debts. Some debts are not, you cannot wipe out. Chapter 13 puts the brakes on all these debt collectors and says you're only going to get a little bit of money at a time based on the income of the person, what they can afford to pay. And your attorney can actually work with the creditors through the bankruptcy court to work it out. It makes a big difference what's best for you and whether bankruptcy is right for you.
All right, just a little taste of what's to come. There's lots more to get into. So coming up next, attorney Claude Lightfoot will join the show to talk about personal bankruptcy. So stay tuned. We'll be right back. Hello everyone, welcome back to the show. If you are on the verge of filing for bankruptcy, there are some very important things that you should consider before making that final decision. Joining us today to talk about bankruptcy is attorney Claude Lightfoot.
Claude has been practicing in the area of bankruptcy for decades, and you'll be hard-pressed to find a better legal mind on the topic. Claude, thanks for being on the show.
Pleasure being here.
Spending time with us on this very scary topic. I mean, you say the bankruptcy word, and a lot of people, they get anxious. But
they do.
A lot of need to knows that we want to share with people today, so thanks for being here.
Great.
So just overall, let's just start with the big topic of bankruptcy. What is bankruptcy?
Bankruptcy is a way to manage your debt and get protection from your creditors while you manage that debt. So for most individuals, it's Chapter 7 or Chapter 13. Chapter 7 is called liquidation because sometimes there are assets that can be liquidated for the benefit of the creditors, but the debtor, or the one who files bankruptcy at the end of the process, is seeking a discharge where they're no longer liable personally for those debts anymore, the debts that they couldn't handle.
Let's say that in a little bit more plain English, liquidation of debts.
The process is like this. In all the bankruptcies, and let me just say Chapter 13 is a wage earner plan of repayment. Chapter 11 is typically a corporate reorganization. Chapter 12 is a reorganization for farmers and fishermen. So that in an individual's case, they'll be looking at 7 or 13. In a Chapter 7, there is a trustee appointed, and the trustee's job is to have a hearing to review the schedules, which is the listing of all the debts and all the assets that the person filing bankruptcy has, and to determine whether there's anything that can be liquidated to money, can be sold off. So the trustees, like the liquidator, to give the creditors at least some money. Most of the cases, probably over 90% of the cases, there are no assets to be liquidated. So it's a fear that many people have, but it's not always borne out by the list of particular assets that they have.
Yeah, and you deal with this day in and day out, so people are very afraid of filing for bankruptcy. I mean, it does conjure up a lot of scary thoughts. How do you help people figure out if, in fact, they should file for bankruptcy?
Well, the first thing that I do, and that has to be considered by anybody contemplating bankruptcy, is to go through all of their assets and to go through all of their debts. And on a daily basis, I do that over and over to try to get a financial picture of what the person is dealing with. There are things called exemptions which protect a lot of property that a person lists in their bankruptcy.
And just to be clear, it's not just what you have in the bank account. It's not just the property you own, car, house, furniture. It's also your ongoing income if you have a job. That's an asset as well, right?
Well, once you have filed, anything that the debtor, the person filing, acquires after the bankruptcy by their work is their money. There's only one exception to that. If there is a death that occurs within 6 months after the bankruptcy, the inheritance comes back into what they call the bankruptcy estate, or in other words, the trustee has the right to that inheritance for the 6-month period after. Otherwise, anything that's acquired after the bankruptcy belongs to the person.
And I guess what I should have prefaced that with, that's in the case of a Chapter 13 where you're trying to manage your debt, not liquidate it or make it go away.
A 13, you're figuring out a plan, and that plan's based on your future income, and there will be a plan payment that's made to a different type of trustee. The Chapter 13 trustee is simply a dispersing agent for the money voluntarily paid by the debtor, the person filing bankruptcy, to the creditor.
And honestly, you were talking about Chapter 7, so make sure, let's talk further about Chapter 7, make sure we define it clearly.
Okay.
So assets, they show up, or whoever's going to talk to a bankruptcy attorney and consider bankruptcy, you ask them to show how much do they owe and how much do they own.
All the debts, and then all of the different assets, and then the first thing to do would be to review the assets with a view toward these exemptions, which are protections of property in bankruptcy. These are things that the trustee cannot liquidate. And these same laws, by the way, apply outside of bankruptcy to creditors who are seeking to collect in the state court system. But the big one, of course, is the homestead exemption. An additional $35,000 of protection on the family home is available to protect the house. So, for example, if someone has a house worth $100,000 and they owe $75,000 on the mortgage, that house would have to be worth more than $105,000 before there would be any equity for a trustee to attach. That's how someone keeps an asset through the bankruptcy. Even if they had to list that house because of that exemption, and as long as they're current on their mortgage, a trustee would have no interest in that particular real estate because there's not enough equity to sell it and obtain a profit.
Well, and that's one of the big fears, is that you're going to lose everything if in fact you do file bankruptcy. And I know this is a conversation that you have with people who come to you all the time. How does that conversation generally go? How do you explain to them it's not necessarily losing everything?
Well, the first thing is to get that valuation on the house and know how much that house is worth. In the case of a car, even a car that has no debt on it, it's a paid-off car. We at least have an exemption on one car per household for $7,500. So someone who's worked long and hard to pay their car off, unfortunately, it's not worth what it was when they bought it.
Right.
And many times it is worth less than $7,500, and so that car can be protected as well, and they get to keep that. Of course, very old cars are not likely to generate a lot of interest for liquidation by a trustee, so even things that you would think would be up for grabs as a practical matter sometimes are not liquidated.
So that's $7,500 on the car. That's the equity in the car. Let's say they owe money on the car. They're still making payments, but maybe it's a $10,000 car, but they only owe $2,500 on it.
Exactly. The $7,500 can be claimed on the car to protect that equity.
Okay, but if it's a $10,000 car and it's paid off, are they forced to sell it, but they get $7,500 back? How does that work?
Well, then you would list it, of course, in all the different chapters. All the assets are listed and all the debts are listed. And I would prepare the person filing bankruptcy that, look, the trustee may be interested in the car. And if the person, through the help of family, friends, co-workers, if they could raise some money to offer to buy a car that had too much equity back, to basically buy it back from the trustee doesn't have to sell it.
Okay.
as long as the trustee can generate sufficient profit from it.
So, Claude, help us understand, when you're looking at all this information that a person brings to you, you're looking at the financial statements, the assets, what they are bringing in versus what they owe. What are you looking for to help determine whether they need to go forward with the bankruptcy or simply go and try to manage, pay off their debts to the creditors?
Well, I would look on a Chapter 7 case where you're looking for a complete discharge of all the debts without making any payments at all. I'd look at, well, how much debt do you have? And how much ability do you have to really work it out? Are you just in between jobs? Are you really going to be going back to work and you really don't need Chapter 7? Also, I'd look at whether the debts that the person has are the kind that can be discharged. Recent tax debts, for example, income tax debts from recent years, less than 4 years, let's say, are generally not dischargeable. So if someone has debt they can't escape with Chapter 7, that's not doing them any good. Additionally, student loans are the other big one that people have, which are not dischargeable in Chapter 7 bankruptcy.
And when you're saying dischargeable, you're talking about wiping it off, wiping the slate clean, so to
That's
speak.
where your personal liability is extinguished. When the case is over and the discharge is granted, no longer owe that debt to that creditor anymore.
But it will still show up on your credit report, correct?
It probably will,
Yeah.
as well as the bankruptcy filing will show.
Will show that.
So for a credit provider who reads the credit report, it's helpful sometimes when someone has more debt than they could ever manage, no matter how many lifetimes they had. It's helpful to have that sort of bright yellow line, as I call it, across that credit report saying, okay, for a future credit provider, everything above this line is wiped out. I know that this person is rebuilding. I know that they can't file another Chapter 7 for 8 years. Their income looks good now. They're back to work if they hadn't been. And they're a bet now, a safer bet for credit that they wouldn't have been able to qualify probably before the bankruptcy.
I wanted to ask you, and we're running short on time on this segment, but can you give us a thumbnail sketch of how Chapter 13 is different from Chapter 7?
Chapter 13 is typically used instead of just to wipe out debt. It may be someone, and the typical case that I'll give you is someone who's behind on their home mortgage. They're facing foreclosure. They are employed. They are making sufficient money to pay it, but they had a temporary problem that prevented them. Now they can't raise the lump sum to catch the mortgage company up, and they need time to pay back. Chapter 13 gives them that. It stops the foreclosure and allows them to pay back over a 3 to 5 year period that delinquency on the mortgage company that had built up.
And you mentioned that with a Chapter 7, you have to wait 8 years to file again a Chapter 7. What about with a Chapter 13?
In Chapter 13, if a case is completed, and as I say, they typically last 3 to 5 years, you could file another case within 4 years of the case that's completed. So sometimes people will have a problem. For us, it's been hurricanes. They might have had to use a Chapter 13 at one point and then been devastated and had to come back and use it again. But there's a 4 year in between period, and 6 years for certain circumstances.
Does it happen often that people have to file more than once? Actually, if you could hold that thought.
I'll do that.
Hold that thought, and we'll let you answer that question when we come back. Coming up next, though, we're going to also include your questions about bankruptcy, so stay tuned. We're back right after this short break.